Okay, what are we at? 14? Maybe it's 15. All right, again, we'll come down to that. I'm glad I didn't know I was writing this for this purpose, but now that I'm using this, it keeps me more in line. I have a tendency to commingle things just like many people commingle laws. I've got so many things, as you see, as I deconstruct this, how each one, if you don't have the preemption to that thing you're speaking about, will contradict itself somewhere along the line. And it's very difficult to speak to any one matter because there's so much evolving into that one word or that one idea. And this is working fine. I hope it's working fine for you. Courts. Judicially an independent institution unto itself. The predominant court is the high courts of chancery, which have been granted the right to administrate over the sales and leasings of settled estates under the common law settlement. How do you know that's correct? Even though I wrote it, how do you know that's correct? You go to the Settled Estates Act. What's the acronym for Settled Estates Act? You're going to love this. C. Settled Estates Act, 1856. That is, which was granted, again, the court still had judicial independence from 1701 in the Act of Settlements, but they received full power to administrate over sales and leases of settled estates under the settlement. What's the settlement, if you remember? Common law, the land interest, which is the warranty of the Settled Land Act. And if you start reading some of the Settled Land Act, the law of property, you can see that one is the hierarchical system, that the common law is the hierarchical system to the equity. Okay, it's the same thing. It's just mirroring each other. So under the settlement, and we'll read those words. You'll read right here: administrate over the sales and leasings of all settled states under the common law settlement, which is the foundational principle of the Settled States Act. It will read that. That's what it's doing. It's granting that power to courts to administrate, the high courts of chancery, those interests. Okay, right there. See, sales estates under the settlement. Courts are recognized as judicially independent from monarchy, parliament, and government in 1701 as per the Act of Settlement. So I love that we're continuing to repeat things as we move down there. I get this little red, in red words that I wrote here. Is it remember law of merchants? Hopefully I do. I don't know if I should infuse it in here. The next thing we're dropping into is citizens. Should we go into the law of merchants just briefly? Why don't we do so? Because it might work great here because I just talk about the C. Okay, and there's different meanings of C. Now, the Settled States Act is where you go in order to get your settlement. It's to which the courts use in order to understand the settlement you have before, okay, which is in the common law. It separates. It's to separate between the common law and the equitable interest. Okay. Now, as we progressed through the common law, which we've already went into, and in as much the rights of use to land, instead of being directly related to common law, and their black and white policies, and its stringency and its harshness. At the same time, we've had interactions of ships and people coming in and bringing in their wares to sale. Okay, so we're expanding upon what people are able to buy. Now, the ones that were on the land or held an interest in England had first right into the villages that were selling their wares, or certain markets, if you will, and they had first right. So they had to notice the difference between that right and those who were coming abroad, to which those ones coming abroad had a separate market that would interact with the rights that were already established in order to keep the economy going within the system that was already structured in England. So as wares came in, they became their own markets as well. They created certain markets for people that were coming abroad from ships and bringing in their wares. All right. Now, those laws are separate. The issue that was a feature that if you had an issue within a disagreement between the merchants or disagreement between the patrons and the merchants, where would you go to? Okay, laws and equity were that feature in which you can come in under, but the common law, there might be some overlapping instances where you're starting to deal with the land interest somehow, and how do you deal with that? And there was confusion, there was issues with that, to which the people that were merchants needed quick settlement. Well, those are the kings of the court, and there's common law issues and so forth, and some of the courts of chancery weren't able to affect that because they had their own procedures that then created, as we know, the bureaucracy that we're dealing with now, that, oh man, I got to do this, I'm going to settle that. And to merchants, money's everything. I'm in here on land for 1 week or whatever the case may be. Here's my tenure. And now I have this problem, and I can't go past this problem until it's settled. To which then became courts called the dusty foot courts, as they would call it, because they moved so fast, the dust didn't have time to settle. You went in quickly, I have this problem, that problem. It still was an equitable disagreement. It was also ascertained whether it dealt with more of a property interest of land than it dealt with a disagreement of wares, which is a different of things rights, and became dusty foot courts. Now, I only want to mention that because you can see that's predominantly what we're dealing with now. Where in 16th century, Cook, which is one of the predominant justices that Blackstone's always brings in to affect his dialogue of, give some substance to his commentaries. He brings in Cook. That Cook started to see the power of the law of merchants and how some of the property rights and law of merchants and the things became overlapping. So he started to integrate that into the courts, the king's courts, because just like what happened when the king's courts were losing business because of equity, the same thing, king's courts and else were losing values and rights and so forth to retrieve money in the king's courts from laws of merchant, for the merchant disturbance. So that's how they integrated, and that's how we all pretty much see everything duplicated when we say a lot of the terminology and the words we use, a lot to do with water, bailment, can't hold your head above water. People, you start using these philosophies that you're born out of water, the ship, you're docked. We started using words that were closely and relative to the laws of merchants and admiralty law, which really what it is still separate, but there is a new settlement of cohesiveness of understanding property and law of merchants together. Again, not common law directly, but again, that started to develop. Okay, and courts of equity started to deal with those more predominantly, and they started to become fused. Even though they're separate entities, if you wanted to deal with that separately, they fused in which things overlap to come to the point where we hit the judicial tracks, and now we're only dealing with one subject and never the other predominant subject that holds our predominant rights. Okay, I didn't get the citizens. I think that's going to be something I should go into another video, but I wanted to get that out. That's how we started getting our words, and then we started using those words to think that we're saying something to exercise our rights. But now we're not. All we're doing is giving value and substance to those rules we no longer want to be under.